Learning Plan 3, Part 2. Let's start on talking about torts. I'm not talking about desserts here. Torts are civil actions where the plaintiff is trying to get a financial compensation from a mistake, error, or action. These are, you could have an intentional tort or an unintentional tort. Intentional tort, something is results from a deliberate act. For example, a while back, the maker of the COX-2 inhibitor, Vioxx, deliberately hid bad medical research. That's an intentional tort. They took specific action to do something that they knew was illegal. Unintentional torts are accidental events, accidental product contamination. It's an accident. Something bad happened, but nobody meant to do it. But still, somebody can bring a tort suit against the person. And if you ever watch TV, you see the lawyers on TV all the time talking about mesothelioma, call now, or I've seen things for bladder sling meshes, and those are all lawyers who are trying to develop class action lawsuits in the tort courts. Yeah. So that's what a tort. If you ever hear tort law or tort reform, they're talking about changing the ability to get money from an accident. Now, let's talk about malpractice quickly. This is a very important concept because I think malpractice is something we know what it means, but we don't really know what it means. Malpractice. Would this be an intentional or unintentional tort? Most commonly, it's going to be unintentional. It could be an intentional tort, but usually unintentional. For there to be malpractice, there must be four things. Must have four things. Malpractice requires four things. There must be a duty. So in other words, there must be a nurse-client relationship. There must be a breach in the duty where the nurse did not meet the accepted standards. The breach must be a foreseeable cause of the injury. And damage must have happened. Four things. Duty, breach. The breach must be foreseeable as the cause of the injury, and there must be injury. If there's no injury, no harm, there cannot be malpractice. In between 1990 and 2003, there were 16,339 cases of malpractice. That's a lot, right? 1,236 a year. But the reality is that there was 2.3 million nurses in 2004. So really, one malpractice event for every 2,230 nurses over a 13-year period. Do you have malpractice insurance? You can get it as a student. It's very inexpensive, and then if you carry it over as a professional nurse, it will continue to be relatively inexpensive. I don't have it. I've never paid for it. Just haven't. So let's talk about the specific elements of malpractice. Okay. So first off, the plaintiff must prove his or her claim. The plaintiff needs to prove that there is a nurse-client relationship. So if you were a staff in the hospital, if you're a staff nurse in a hospital, but never took care of the patient, they were never assigned to you, you can't be held liable. Even if you were on a team, but never worked with that patient, you're not responsible. So then we look at the scope of practice, or the duty, and the Nurse Practice Act determines the scope of practice act. Let me try saying that again. The Nurse Practice Act determines the scope of practice. If you act within the scope of practice, you are protecting yourself. When you act beyond it, or don't act to the levels, that's when you put yourself at risk. So if you do something you've never been trained to do, you are at risk. Likewise, if you've been taught to do something and neglect to do it, that's a problem for you too. Would you ever render assistance to a person that collapses in public? Or would you help out in a motor vehicle collision? See, immunity is granted under the Good Samaritan law, okay? But it's not blanket immunity. It's granted, but only as long as you are attempting reasonable actions. I did stop at a motor vehicle collision one time. I watched it happen. I got out. I grabbed the person. I pulled the person out of the wreckage, and I began CPR. They never revived. But I was trained in CPR. So they died. Actually, they were dead before I got them out of the car, I think. But I'm not responsible. I broke ribs. I'm not responsible. That's part of the act that I was trained for. What if the person had had a bad throat injury and I decided I was going to do a tracheotomy? You know, just cut in there and put some sort of tube in there and help them breathe? Could I do that? I probably could do it. If I did it and that resulted in death, am I responsible? Oh, yes, I am, because I've never been taught how to do a tracheotomy. I've never been trained how to do a tracheotomy. Knowing and being trained are two different things. So you need to understand what a reasonable action is. And a reasonable action is what you've been trained to do. That's all. Now, what about the duty? How do you prove that a duty exists? Because it could be your word against theirs. Well, there are a number of ways that you can prove that a duty exists or didn't exist. Each state has its own accepted guidelines. You could have an expert witness. These are paid experts coming in, generally a nurse with a similar role as the defendant, who report what they would do in a specific situation. Now, if you were on trial as a student nurse, they would not call me as an expert witness. I've been a nurse for 19 years. It's unequal measurement. They would call another student nurse from your school to prove what your duty should be. They might look at the accreditors. Many organizations provide accreditation and set basic ground rules that must be followed. They could look at resource materials. What source books are available in the workplace? A Davis Drug Guide, a Perry and Potter skills book, a drug, anything like that can be used to say this is what the nurse should have done. And saying, yes, we have them, but I didn't have time to look it up, will not help you. Not at all. So, and since more and more people have many documents on their handheld devices, resource materials is a really hard one to prove wrong. And then the accepted standard. This is related to accreditation. The plaintiff could look at a generally accepted standard of practice and say whether or not something should have happened. The ANA, the NLN, the AACN, the ENA, many organizations set their own general standards. So those are how duty is proven. Now the breach. In the quote on the slide, it's a quote from a Shakespeare play. In the quote, the breach refers to a part of a castle or wall that was broken down. And so there's a breach in the wall, and what happens then is the commander, the king, orders all of his troops into the breach to either repel the invaders or plug the hole with their dead bodies. Seriously, that's how you plug a breach. In a malpractice suit, a breach is when a nurse breaks his or her duty. The only time a breach is significant in Shakespeare's time is if there are invaders. If there are no invaders and part of the wall falls down, there's a breach, but there's nothing wrong. It's just there. Similarly, you can have a breach with a patient, but if the patient did not experience injury or other harm, and it could be mental or spiritual or psychic harm, if there's no harm, then the breach doesn't matter, and there's no malpractice. So, there must be a duty. There must be a breach. The breach must be a predictable. It must be an accepted causative agent of the injury, and there must be an injury. 4 things that are required for malpractice. How do you protect yourself from malpractice? Document everything all the time. clearly, objectively, frequently. Don't wait to the end of your shift to do all your documentation. Document as often as possible. So I know you students always document your assessments, medications, vital signs. Do you ever document patient emotions, actions, patient visitors, and the visitors' comments? Do you ever document about compliance, patient compliance or non-compliance? Suppose you needed to get a person up and they refused a gait belt. Did you document that they refused a gait belt? Have you documented how patients interact with others? Or things that the patient says in quotations? Document verbatim quotes. Those are all bits of information that could protect you if something were to go wrong. So you need to prove cause and effect. And that's that third piece. We need to prove that what happened led to the injury. So if a patient is walking with his or her nurse and they fall, okay, that's one thing. If I'm walking with a patient and they fall, okay, but if I didn't put on his gait belt, that's a bigger mistake, right? But how about this one? I don't put on his gait belt. He falls, doesn't get hurt, doesn't even get scared. No injury. So there's no malpractice. If something goes wrong, document objectively what happened. What did you see? What did you hear? What did you do? What did the patient say and do? Document verbatim. Do not interpret what the patient meant. Write verbatim quotes. If there's no injury, no harm, there's no malpractice. Now, that does not mean that you did not make a mistake, but you cannot be sued for malpractice. Now, in lawsuits of like this, in tort cases, injuries equal money. Okay? And there are three types of injuries, or there are three types of awards: general, special, and punitive. General damages are for loss of employment, pain and suffering, and very subjective losses. And those can be quite large. Special damages are money to compensate for out-of-pocket expenses, lost wages, and other financial losses. These are very objective because you can add up all the money spent and lost. Punitive damages are punishments. That's it. These can get huge. Now, what can make them get large? The age of the person who got hurt, for one thing. The very old, the very young, low awards. Because the very young, I'm talking like, let's say, 2-year-old, you have no idea what that person's going to do when they grow up. So, in legal terms, a 2-year-old's not worth a whole lot. Back off, okay? You know what I mean. Financially, in this lawsuit, a 2-year-old, a 4-year-old, a 6-year-old, they'll get an award, but it's not going to be huge. An 85-year-old, they're at the end of their life. They're not going to get a huge award. But a 40-year-old parent with a family, they get the huge awards. Why? They have more at risk, more responsibilities, more need. Now, you also have to look at the type of injury. Is it disfiguring? Visibly disfiguring? Permanent? Is it disabling? Yeah, those all result in huge awards. What causes the largest awards? Well, a malicious act, an act that you did on purpose, will almost always result in huge, just massive awards. But the worst thing you can do then is try to cover it up. If you cover it up, it's going to get really bad. So liability is another word for responsibility. And nurses have personal liability. Physicians and other licensed providers, though, they have something else called Respondeat superior. Now, Respondeat superior is a key legal idea that says if the doctor made a mistake and the nurse missed it, and acted to harm the patient, the nurse shares liability. But if the pharmacy sends up the incorrect medication and the nurse gives it, who's responsible? Probably the pharmacy then. Respondeat superior, it functions at the institutional level. Respondeat superior is the master is responsible for the act of the servant. That's legal. Respondeat superior, just remember, the people in charge are responsible for the people beneath them. So if malpractice is suspected, initially everybody will be named in the suit. You, the facility, the physician, the CNAs, everybody's going to be listed in that lawsuit. And while the facility may have some liability, you will need to prove that your actions were correct. Don't assume that the facility will necessarily have your back. But with Respondeat superior, sometimes people just go for the people with the deep pockets, the doctors and the facilities. You'll never assume that will be the case if you're jointly named. But generally, if you are in a list of people and there are agencies and people that have a lot more money than you and they're responsible for you, Respondeat superior will fall into play and they will be more responsible than you. Student liability, you're not going to have to worry about this very soon, but students are responsible for your own actions. If you were properly taught a skill and demonstrated correct technique, but later made an error that harmed a patient, you're responsible. You cannot claim I forgot or something else as an excuse, because we save all those documentation of skills that you've done. But that's not going to happen, okay? The best defense, besides documentation, look at the statute of limitations. The law defines how long a person has before filing a lawsuit, and this varies by jurisdiction. The assumption of risk. If you assist a patient that had just had a hip replacement to the bathroom and he or she refuses to use the walker or turn on the call light and then falls while trying to get back to bed, they've assumed the most of the risk. And contributory negligence. If a patient does not follow discharge instructions, say for wound care, and they develop a post-op infection, they're responsible for their own actions. But the best defense is a good offense. Document everything. Ensure that you have a safe environment, that you have working equipment. Frequent assessments. Keep the eyes on your patient at least once an hour, more often if you can. Clear communication both within your team, above to the supervisory and doctors, and to your subordinates. Clear communication. If something out of the ordinary is happening, let everybody know and document. And complete incident reports immediately. If you file a report because X happened, and 2 weeks later X happens again from somebody else, but the original cause was never addressed, you have more protection because you've made it clear that there's a problem with X, but the hospital never did anything about it. So you can be protected. That's the end of part 2.